Mr Chairman.
I call the Honourable Trevor Mallard.
Mr. Chairman, I think this is probably the best part to make. While it's there are some detailed matters that have to be dealt with, to make a pretty clear statement with regard to these details and these arrangements, and that is that when there is a change of government, and I expect there to be one in November, each of these details will be reviewed, and all comforts that this Minister has given to Telecom and any of the other providers will also be reviewed, and they will not be guaranteed. Just making it clear and on the record that if this Minister enters into contractual arrangements which a subsequent government finds are inappropriate, too expensive, then they will be reversed following a review, and they will not be compensated for. So I just wanted to make it very clear that anyone entering into an arrangement based on this legislation has got to know that it may not last, that like all legislation, these clauses, Mr Chairman, will be, if they are passed, and I expect that they will be passed, will be subject to further parliamentary review and the possibility of amendment without compensation. Mr Chairman, I now want to say why I am so anxious about these, and I want to start where you so kindly interrupted me earlier on, and that goes to the taxation consequences of structural separation. Mr Chairman, I do not understand, and I don't think any reasonable person can understand why a particular telecommunications company, when it chooses to do something in the interests of its shareholders, should be exempt from the normal taxation liabilities which would occur at that stage. Now, Mr Chairman, there are a number of preferences by way of subsidy, by way of what I regard as a regulatory rort that will be reviewed. It will be questionable whether it's appropriate to review and change past taxation arrangements. I mean, I think it's probably fair to say that retrospective taxation is a bit hard to do, although I might say we will still be within the same financial year. So that is an issue that is something which is relatively important. But I think it is important to place on the record that the Labour Party feels that some of the things done within this legislation are so wrong. And I know it's not the time to have a principled debate about whether broadband is good or not. Of course it is a good thing. It is an important thing. But what we're talking about here, and in the very detail, which we'll get into, is a method of getting there, and the taxation and pricing and penalty arrangements which occur. I do want to make it clear and just say that the idea that the division is not a kind of assessable income it's either the case or not. And if it's assessable under the Income Tax Act 2007, then it should be assessed. It should not be exempt by this legislation. And in a similar way for the Estate and Gift Duties Act of 1968. Mr Chairman, I now want to go to the question of the finance leases, which and the arrangements for them, which are outlined on pages 84 and 85, and ask the question about what is the system of review that ensures that the revenue is not being adversely affected by these transfer arrangements. Or, if, Mr Chairman,
Honourable Trevor Mallett.
Mr Chairman, if the revenue is to be adversely affected by these transfer arrangements, by how much? Is the Minister aware of the cost to the Crown of this treatment of the finance leases? And if so, can he tell the House? If not, can he bring that information to the House on Tuesday? Mr Chairman, I want now to go to the question of penalties, and I think I'm relatively pleased that you effectively struck out my earlier contribution on this question, because I can't now be pinged for repetition, Mr Chairman. But Telecom, and I think 19. I think it's the figure that I got in my head. I can be there. I'm up for correction on that. But I think it is on 19 separate occasions within civil courts. Telecom have been found to be in breach of their competitive requirements. Mr Chairman, Telecom made an art of hiring lawyers in order to keep their competition away. There's potential rivals. Their bodies are littered around New Zealand and around the world, because what Telecom used to regularly do, and to be fair, they were experts, Mr Chairman. They had some of the best lawyers in the country. They paid them a lot. They employed some of the biggest legal firms in order to prevent proper competition occurring. The cost to this country has been enormous. I want to be clear. I'm going to blame. I'm going to take some responsibility for it as a backbencher in the previous government at the time Telecom was sold. There was a significant proportion of the shares went to two American companies, and Americans tend to sort these matters out through legal matters, through the involvement of lawyers, rather than engineers and a competitive approach. And, Mr Speaker, out of that, there has been a development within Telecom of drawing on the lawyers as soon as possible, rather than moving to a competitive situation. And therefore, sir, the point that I'm making is whether $10 million is a sufficient fine for a 69L, which is a failure to comply with or amend sharing arrangements. That goes right to the basis of competitive behaviour. Well, it's a tiny amount, because the billions of dollars that can stand to be gained through those anti-competitive behaviours. Our line of business restrictions, very, very similar behaviours as have occurred. And Mr Speaker, just failing to notify sharing arrangements is only a $1 million fine. Mr Speaker, the keeping secret, having duopoly, having two companies working together through a secret arrangement and a failure to inform others of what they're doing, Mr Chairman, that goes to some of the core of anti-competitive behaviour. And I think you and I might say, well, of course, companies in New Zealand would never do that sort of thing. It's unethical, it's wrong, it's illegal. But unfortunately, on 19 separate occasions, Telecom have been found to act in this anti-competitive manner. And therefore what I am saying is that these penalties are woefully inadequate. They are woefully inadequate, Mr Chairman, and frankly, the continuing breach, where it's only a $500,000 for a continuing breach of 69L or R. That's the sharing arrangement, the failure to comply with the sharing arrangements, or the line of business restrictions. Mr Chairman, those are very, very small fines, when what we are aware of is that there will be billions of dollars available in revenue in this area, and every encouragement is sitting there for these companies, these favoured companies by the Minister, these companies favoured by the Minister's arrangements, to rule.
Said Assembly doing it.
Chairman, Mr. Chair.